Hello, my name is Nathan Reed, and I'm a patent attorney at BSKB. The Court of Appeals for the Federal Circuit ruled on the issue of whether appending routine, conventional steps to a natural phenomenon is not patent-eligible subject matter in the case Ariosa Diagnostics v. Sequenom, Inc., decided on June 12, 2015. This case is likely to cause concern for companies performing basic research in the field of personalized medicine and medical diagnostics. The patent at issue claims certain methods of using cell-free fetal DNA. The steps of the method of Claim 1 of the patent include amplifying the cell-free fetal DNA contained in a sample of plasma from a pregnant female and detecting the paternally inherited cell-free fetal DNA. The claims can be directed to a method for detecting the small fraction of paternally inherited cell-free fetal DNA in maternal plasma to determine fetal characteristics such as gender. The patent also provides for making a diagnosis of certain fetal characteristics based on the detection of paternally inherited cell-free fetal DNA. The specification explains that analysis of cell-free fetal DNA permits more efficient determination of genetic defects, and that a pregnant woman carrying a fetus with certain genetic defects will have more cell-free fetal DNA in her blood than will a woman with a normal fetus. The district court ruled that the claims of the patent were directed to the natural phenomenon of paternally inherited cell-free fetal DNA, and that the claims did not add enough to the natural phenomenon to make the claims patent eligible under Section 101. The district court determined that the steps of amplifying and detecting were well understood, routine, or conventional activity in 1997 when the application for the patent was filed. The Court of Appeals stated, "The existence of cell-free fetal DNA in maternal blood is a natural phenomenon. The method ends with paternal inherited cell-free fetal DNA, which is also a natural phenomenon. The method therefore begins and ends with a natural phenomenon. Thus, the claims are directed to matter that is naturally occurring." Because the claims at issue are directed to naturally occurring phenomena, the court turned to the second step of Mayo's framework. In the second step, the court examined the elements of the claim to determine whether the claim contains an inventive concept sufficient to transform the claimed naturally occurring phenomenon into a patent-eligible invention. The court stated that the specification of the patent confirms that the preparation and amplification of DNA sequences in plasma are well understood, routine, conventional activities performed by doctors in 1997. The court stated that appending routine, conventional steps to a natural phenomenon specified at a high level of generality is not enough to supply an inventive concept. Where claims of a method patent are directed to an application that starts and ends with a naturally occurring phenomenon, the patent fails to claim patent-eligible subject matter if the methods themselves are conventional, routine, and well-understood applications in the art. Although the court stated that detecting cell-free fetal DNA in maternal plasma was previously discarded as waste material, and the inventor's contribution to science has resulted in over 1,000 cites and subsequent publications, the court stated that groundbreaking, innovative, or even brilliant discovery does not by itself satisfy the Section 101 inquiry. Keep in mind, however, the issue of patent-eligible subject matter is fact-specific and decided on a case-by-case basis. Thanks for joining me, and I hope you've learned something today. Stay tuned to bskb.com for more upcoming cases and other commentary on intellectual property.